Okay, we're about to get started. We're going on the record on cause number DC 225281, Oaks on the Lane Condominium Association versus United Specialty Insurance Company. Counsel, make your appearances.
Vincent Cercelli on behalf of the plaintiff, Your Honor.
Savannah Bennick on behalf of Defendant United Specialty Insurance Company.
All right, let's go ahead and proceed.
Good morning, Your Honor. I do have my colleague here, Stephen Hollenbeck. He's one of our younger attorneys, and he will just be listening in today to get some court experience.
Great.
So we are here on defendant's motion to compel plaintiffs' documents and complete disclosures. And the reason we're here today, we've been trying to resolve this issue since June, and here we are. This is a first-party property insurance dispute, and the plaintiff is an HOA, specifically a homeowners association for a condominium complex in the Dallas area known as the Oaks on the Lane condominiums. And this HOA has sued my client, United Specialty Insurance Company, requesting damages due to alleged severe storm damage from a June 9th, 2019 storm, specifically hail and windstorm. And the HOA is seeking millions of dollars. The latest estimate was, I think that was attached to plaintiff's response, was for $4.5 million to repair 18 condominium buildings. That includes the roofs, windows, siding, gutters, downspouts, light fixtures, fencing. This is an extensive alleged repair project here. And one of the key issues in this case is the cause of the damage. So is the damage at this condominium complex caused by this June 9th, 2019 storm, or is it caused by other issues like inadequate or deferred maintenance or improper installation? And since this is an insurance coverage case, it's important to defendants' defenses in the case to know about the maintenance and repairs to the property. And so it's an HOA as the plaintiff, but the HOA has not disclosed any of its board members, any tenants or unit owners, the property's maintenance personnel. Under the new Rule 194, that type of information should be automatically disclosed. These are the persons that one would normally expect would have relevant knowledge of a storm hitting this property. So that's the first big issue, is the lack of disclosures. The second big issue is the documents. As I mentioned, maintenance is an important part of this case, and the HOA has not produced any information regarding the maintenance, condition of, or repairs to the condominium complex before the June 9th, 2019 storm. And again, this is very important because the carrier here, it has defenses regarding deferred maintenance, pre-existing damage, and those types of coverage issues. And we know this type of information is out there because defendant has been issuing a bunch of subpoenas to third parties, and that's one of the reasons we're here today. Is we issue these subpoenas, we get these documents, and then we think, whoa, why hasn't plaintiff produced this information? We see these third parties providing relevant information to the HOA. One example is in 2017, that's about 2 years before this storm, the HOA had a reserve study done to assess future maintenance of the property, including the roofs, the siding, the types of property damage at issue here, and the HOA has not provided that study or report in this lawsuit. Similarly, so the pre-storm information is the first issue in terms of category of documents that are missing. The second is the HOA separately contracted with different contractors and an engineer. And the HOA has not produced all of its relevant communications and documents with some of these third parties. Your Honor, I don't know if I have, it looks like I don't have share screen capacity, but I was going to show one email if I may.
Okay.
Let's see here. All right, Your Honor. This is a email that's been produced in the lawsuit. Bates labeled Pi 1067. Pi is an engineering company that the HOA hired to come out to the property and assess deferred maintenance and do a condition assessment. And we see here that the HOA's property manager on October 25th, 2022 said, there's this active lawsuit. I need to get Pi Engineering's documents to produce them in this lawsuit. And here you see it's Pi or Lurch Bates. There is some sort of company merger, but it's generally the same entity. And up here we see that Pi, this engineering company, provided their documents to the HOA to produce in the lawsuit. The HOA has not produced these documents. I believe we've received one Pi or Lurch Bates engineering document after we filed or provided a draft of the motion to compel. But other than that, we have not received any of this information that was provided to plaintiff to be produced in this lawsuit. And it's important because, again, it's assessing those key issues regarding maintenance. I mean, there's a condition assessment report prepared by Pi regarding the windows, the siding, the gutters, the things that the HOA now seeks millions of dollars for. And then we also know that the HOA invited a roofer with Stars Roofing to come out during the claim assessment and discuss some options with the HOA. He was also called out regarding leaks before the storm. Again, we know this based on third-party documents. And again, plaintiff has not produced that information.
Right, so you have a number of requests here, kind of that are in your. Let me see if I'm share screen. Like, give me a second. I kind of think it makes more sense as opposed to this kind of scatter shot that we just go through the requests. So request 17, I think that's the first one you request production 17. You're asking for all correspondence relating to the condition of the property ever. It seems like that's really, really broad. And so let me
yes.
Yeah, so that's way too broad, but let me hear from the other side and see what their thoughts are.
Certainly, Your Honor, and I'll focus on that, and then I can answer some of these other accusations at a later time. But on that first one, plaintiff is an HOA organization with a revolving board. It's not a highly professional, highly organized set. We have produced pre-loss minutes of board meetings and any reports that we have before the 2019 storm event. We have turned those over. We've searched and researched for any additional documents and turned those over. It's thousands and thousands of pages. The defendant can't point to anything specifically that we've withheld, and we've disclosed. We have disclosed the maintenance workers, the pre-suit maintenance workers, in our interrogatory responses. Defendant has sent third-party document requests, some of which are still outstanding to people we've disclosed. To the extent a third party has it, they'll receive it that way. What we're representing to the court and to the defendant is we have searched for, gathered up, and produced everything that we have pre-suit related to the pre-storm related to the condition of the property. And I can talk about the post-lawsuit engineering reports and
one at a time. So let's do a 17. So this asks for correspondence, but before June 9th. So I'm going to require you to produce any correspondence, if you haven't, on 19, 5 years prior to the storm, related to the repairs to the areas that you claim were damaged by the storm.
Understood, Your Honor.
Okay. All right,
you.
the next one is request for production number 2.
I may, and Judge, I don't want to speak over Ms. Manak or you. That same order that you just gave may apply if you want to make it the same type of language to number 2. We'd be totally agreeable with that. And to the extent we have it, it's theirs, because I think it's the same general.
All right. Well, this just asks for January 1st, so it's even less than that of 2017.
Yes, Your Honor. Request for number 2 is really one of the most important
Yeah,
requests in here.
So I'm going to overrule the objection. You need to answer that one.
Okay.
All right, let's go to the next one. For production, request for production number 5. Yeah, I mean, it's just since January 1st of 2017. I'm going to overrule that objection if you need to answer it if you haven't already.
Judge, on that one, can we discuss one just post litigation question? Because it's agreed before this, before the litigation, we do have engineers who have come out and who have, helped.
All right, except for any consulting only
Perfect.
experts.
Thank you.
They're not relied on by a testifying expert.
Your Honor, if I may, I believe there's a dispute as to whether an engineer's work is protected under that consulting expert privilege. Our position is that under the Texas Supreme Court's Axelson case, if an engineer is out at the property, inspecting the property, that engineer is a discoverable witness. They have factual knowledge of this property, and the information we received today indicates that Pi was hired by the board over a year, I believe, before this lawsuit. That Pi is not, even if Pi was later hired by plaintiff's counsel to be a consulting expert, Pi certainly was hired by the board to generally assess the condition and maintenance of the property. And we know Pi is overseeing repairs to the property right now based on third-party documents. So we just dispute that Pi is their work is protected under this consulting expert privilege.
Response?
I may have missed that case. I didn't see it in the motion to compel. I didn't see that briefed, but I would say that post litigation, post storm, experts who are out helping to assess and give guidance to the HOA on this specific issue of storm damage, those are textbook consulting experts. We have retained designated experts. We've produced everything that they relied on, their opinions, their scope, all those things, but we're allowed to also consult with consulting experts and keep those from being discovered in this exact scenario, on this exact topic of the storm damage.
Did you brief this issue?
Your Honor, it was briefed in the reply in response to the consulting privilege objection raised in the response.
I didn't get a chance. I mean, I didn't get a chance to file a SIR reply. I think that was filed on Friday. I didn't see
Your
it.
Honor, it was filed on Wednesday.
Okay, Wednesday.
Why don't you share screen that case so that we could take a look at it?
Yes, Your Honor. And Your Honor, I don't know if you received it, but we sent a binder to the court on Friday. If you'd like a hard copy, it's in the back of that binder.
Yeah, I don't have that.
Okay. This is the case, Axelson. And right here, the court discusses dual capacity witnesses, and it discusses an engineer that was out at a wellhead that blew up. I believe this was out in West Texas, and there was a person who was out there during the investigation of the wellhead and then later brought in as a consultant. And then there were other people who examined the wellhead equipment and had knowledge about the chain of custody of the wellhead. And the court said that these witnesses have factual knowledge and are therefore discoverable fact witnesses. And
so it says the factual knowledge and opinions acquired by an expert who's an individual who's an expert and an active participant in the events material of the lawsuit are discoverable. This information is not shielded from discovery by merely changing the designation of a person with knowledge, relevant facts to consulting only expert. I mean, it seems like that was a situation where the person was out there when the well blew.
Your Honor, if I may also add that we subpoenaed Pi Engineering's file, and plaintiff did not object to that. And so we do have Pi Engineering's file. We just don't understand why plaintiff is not producing it. It just producing its communications with Pi Engineering. And it seems like this consulting expert privilege is now being made on the back end to try to shield harmful evaluations regarding maintenance to the property from defendant.
Judge, I mean, again, if we do stand on those objections, we've consistently put it in. Pi didn't come out until afterwards. However, to the extent they already have any documents, this is a moot argument. This is the problem with filing these motions. If they can get things from third parties that we don't have, or that we're, on this case, we're objecting to, there's no basis for them to also compel communications from us. But we stand on those objections. This one case is not applicable because it's not a hybrid witness. We're not putting this witness as someone with factual knowledge of the condition of the property prior to the storm. They came in after to help repair and maintain it, but that's not relevant to the issue here, which is, was this building damaged by the storm as we allege?
I haven't read this entire case, obviously, and so I'm not exactly sure what it says on. Obviously, if this person was providing, this expert was providing expert engineering services prior to or during the incident, I agree that would be discoverable under this case. I can't tell from this case, which you've showed me so far, if post-incident discovery would also be, or activity would also be discoverable. If it is, then that would really gut the consulting only expert. But does it go into that issue?
It looks like, Judge, even in that highlighted section on under heading 8, where it says the rule will not extend to consulting only experts whose only source of factual information was the consultation. That's what we have here. They came in to consult after the fact. It's undisputed that Pi was not involved prior to or during the storm. And so, I'm sorry, it's just above that header 8. It's in header number 7. Let's see.
And Your Honor, if I may respond. So this is not an engineer that was brought in to evaluate or some documents. This is an engineer that went out there, prepared a report with about 300 pages of photos. And if I may briefly show the portion of the retention letter with the HOA, the expert has to be brought in for the purpose of litigation. And here we see that it's also on the motion, in the motion on page 12, which I can bring up, but let's see. This engineer was hired by the HOA to assess deferred maintenance, which is relevant to this lawsuit, not hired to be a consulting litigation expert. And I'm trying to pull up this portion of the, here we go, motion. Here we go. So on page 12 of the motion, we include a snippet of the letter where we see the HOA retaining PI to prepare a condition assessment. Over the years, the natural aging of the building systems has caused varying levels of deferred maintenance to each of the structures on the property. So that's why the HOA hired this engineering company, not to be a litigation consulting expert. And our position is this information regarding maintenance is highly relevant to defendants' defenses in this case.
Response?
Sorry, short response on this letter. It's a letter from PI seeking the services. This is not the plaintiff saying, here's what we want you to do. This is PI saying, here's what our firm does, here's what we can do. It's a proposal from PI, not from the company. And again, the date is important, June 2021. This is in the heart of the dispute of, is there coverage, is there not coverage? The retained testifying experts are going out at the same time, looking at the same things, doing the same type of investigations. These are textbook post-incident consulting experts who the HOA hired to analyze this. And defendant has our official statement on this, which the rules allow, which are our designated testifying expert reports. So that's what they're allowed to look into. It's not a hybrid witness. It's not a witness who we're going to rely on for some factual.
Is there an actual retention agreement with this expert?
I believe there is an actual retention agreement, yes.
Do you have either of you have a copy of that?
I believe I do. Let me see.
And Your Honor, I'll also look for that. That was going to be a suggestion of mine, is if this is truly a consulting expert, then ask the court to do an in-camera review of that retention agreement. I haven't seen any retention agreement, of course, with plaintiff's counsel. Just at the.
I'm sorry, guys. I'm not 100% sure. I thought we did. I will look. But it may take me some time. And as soon as I do, I can report to the court or to opposing counsel, and we can talk about it. I'm looking now, but I don't see it.
So, Ms. Banach, you're going to be preparing a ruling on this. We're going super slow. So for that particular expert, I'm going to allow you to request an in-camera inspection of for me to do an in-camera inspection of their retention agreement to make a determination if they're a consulting only expert. Otherwise, you have my ruling on that. So we need to go a little bit quicker now.
Yes, Your Honor. Thank you.
All right. Request production number 9. I don't know.
Your Honor, a lot of these
requests. Wait. Let me read it first. I'm going to overrule the objection. Number 15, I'm going to overrule the objection, but I'm going to limit it to areas of the property. And same for 9, for both of these, limit it to the areas of the property that you claim were damaged by the storm. And number 20. Is overruled. Objections overruled. 29 is overruled. Looks like you're also requesting a ruling on 30.
Yes, Your Honor.
Judge, we'll withdraw. I mean, we'll withdraw on that one. If it's just communications, we'll agree to produce anything we have in regard to that. Other than, I guess our only objection is communications that are privileged between the HOA and the attorneys, obviously.
Right. That's fine.
Okay.
Mm,
But it says non-privileged, so we'll withdraw our objection.
all right, and then request for production number 1. Yeah, request for production number 1 is overruled. Objections overruled. Okay, I need a little more on 18. It looks like produce all correspondence between plaintiff and any person, including strata, Eagle Martin, and any mortgage holders, property owners, or tenants relating to the condition of the subject property after the June 9th, 2019 storm referenced in your petition. Who are strata, Eagle Martin? Who are they?
Your Honor, those are insurance adjusters and the third-party administrator. The reason I put this request in here is really the property owners and the tenants. We haven't received anything, any communications to the HOA or the property manager from tenants or property owners.
All right, so I'm going to limit number 18 to just property owners and tenants correspondence.
And Judge, could I have just a really short response on that?
Sure.
This is remember, this is post-storm communications between the HOA and its members about the condition of the property. To the extent we have privileged communications that discuss the lawsuit, the need to file a lawsuit, the plans to file a lawsuit, I'm fine to produce non-privileged communications.
But a communication between an HOA board member and a tenant about the lawsuit is not going to be privileged unless there's counsel involved, right?
Well, if it's work product, even non-attorneys can have communications related to work product, because it's work product. Things like we need this for the litigation, or things that the attorneys ask them to do would still constitute work product, even without.
If you want to create a privilege, I can't imagine that's going to be the case, but if you want to, you're going to be allowed to assert a privilege log if there's some correspondence you believe is privileged. I don't foresee that's the case. All right, is that everything? That looks like the end of the motion.
Yes, Your Honor, that's all that I have.
All right, so go ahead and prepare a order for me. Make sure that the order says this was heard on October 9th, 2023. Make sure it goes through every one of my rulings specifically. Share a copy of the order with Mr. Cercelli, and give me the order by this Thursday at 3.
Thank you, Your Honor.
Thank you, Your Honor.
All right, anything else, guys?
Nope, that's it.
No,
Thank
Your
you.
Honor. Thank